But we're going to specifically talk about admissions requirements. We're going to talk about admissions preferences and the difference between them. Talking about the public random drawing process and some of the things that we recommend around that process and pupil outreach. And overlaying all of this, Lisa, our resident expert, will be talking to you about how all of what the Charter Schools Act says, and maybe even what it says in your charter, is possibly changed by the fact that if you go through the Department of Ed for a public charter schools grant program grant and receive it, some of the things we're going to say will change. So what we've tried to do in the slides is we have a slide that talks about the legal requirements, then we have a slide about the practical requirements. Here are the legal requirements around admission requirements. And then some of you may or may not be aware, but the charter schools actually have the right to establish admissions requirements. Whether you go about doing that and how you go about doing that, we'll talk about in a moment. But there's a number of laws that impact the admissions requirement aspect of charter schools, and they're not all consistent. And so they need to be harmonized. We'll talk about some of those today. The first one, it's kind of buried in the second bullet here, is that the law says you have to accept all students who wish to attend your charter school. But then it goes on to say, looking at the first bullet here, is that you can have admissions requirements if they're stated in your charter. And that's going to be a refrain you're going to hear very often from us, both on preferences and preferences and admissions requirements. They have to be in your charter. We'll talk about this, things over the course of practice and history, policies will get written and things will change, and all of a sudden you've set barriers to entry or preferences in the lottery process, and if they're not in your charter, you could be running into some problems in the future. So you can have admissions requirements. Some of the other things that circumscribe admissions requirements are that they have to be non-discriminatory. And that makes specific reference to another section of the code that talks about the fact you can't discriminate on the basis of disability, gender, gender identity, gender expression. You've probably got a better idea of what some of these mean in detail. Nationality, ethnicity, religion, sexual orientation. Well, I've never dealt with the gender expression issue, but I can only imagine. As I said before, you have to accept all students. You can't charge tuition. And while all of us would probably think tuition means in the code, initially we can't put up essentially a fee barrier to entry, meaning you have to donate a certain amount of money either to join the school or contribute a certain amount of money on an ongoing basis. The anti-tuition provision in the Charter Schools Act ties to a provision in the California Constitution that's a free schools guarantee clause, which requires you to provide schools free of charge. And you may have seen some of the legal alerts coming out of our office talking about an ACLU lawsuit against school districts because of the extreme financial pressure in the state. Everybody, and I'm sure charter schools are included, are trying to find ways to get extra money. You know, mandating donations at parent orientations around enrollment, or at least implying that if you come to our school, you may have to donate money in order to be sort of enrolled in the school, are all things that might be dubbed tuition, or at least things that would stand in the way of an open admissions process. If we want, or if anybody has any questions about what you can and cannot charge for while you're operating a school, I'd be happy to stick around afterwards and talk about that. And then obviously we have to be non-sectarian. We can't be affiliated with any religious organization or institution.
So
grab the last
we also have legal requirements related to the minimum and maximum age of attendance. Our minimum age of attendance is because even though we are charter schools and we are subject to what we call the mega waiver, we do not have to comply with all laws that apply to school districts. One of the laws that we do have to comply with is minimum age requirements for public school admission. And those have changed recently, and so it's important to jot it down that it used to be 5 by December 2nd. And this year it continued to be 5 by December 2nd, but next year it's 5 by November 1st to start school. And then the following year after that, it's October 1st. Following year after that, it's September 1st. So by 2014, 2015, your students who are admitted for the 14-15 school year have to be 5 by September 1st. And then it stays at September 1st from here on out. There has been some questions that have come to our office about transitional kindergarten. As you all know, the law that talks about minimum age requirements says that a charter school and a school district may receive funding for transitional kindergarten if it offers a 2-year kindergarten program and basically hits those students that fall in the gap between September 1 and December 2nd. You know, actually this month, for this year, it'll only be a 1-month gap, the following year a 2-month gap, etc. There's been some questions as to whether charter schools and school districts have to provide transitional kindergarten. I don't know if any of you've raised this issue. We called the Department of Ed early on, and they said that they have opined that school districts have no choice. They have to offer a transitional kindergarten, but that they are not making an opinion as to charter schools. Now, when I look at the law, I actually come out with a completely different answer. My answer is that only if you want the funding for transitional kindergarten do you have to offer transitional kindergarten. That's sort of where I come from a legal perspective. What I understand now is that it's likely that the governor's budget is not going to include the transitional kindergarten funding, so it's probably irrelevant, and then none of us are going to be doing transitional kindergarten. But it's worth noting in case that question was raised. Now, how many of you are serving students who are over the age of 19? Anybody? A few. Now, as charter schools, we do have the ability to serve students up to the age of 22. However, we can only receive attendance apportionment for those students who are over the age of 19 if they are enrolled in a public school at the age of 19 and while 19 remain continuously enrolled, so no exiting the school and coming back, continuously enrolled and making satisfactory progress towards a high school diploma. And then there is a cap of age 22. What is satisfactory progress? Our regulations actually define satisfactory progress in a fairly complicated way. It means uninterrupted progress. So basically, it's a comparison to the comprehensive high school in the district in which you are authorized. Now, if your authorizing district does not have a high school, it's the high school in the largest high school in the county. The largest high school in the county in which you operate that you're judging your program against. And it's basically making sure that they can complete through the sort of full-time attendance in the aggregate amount of a time that they would in sort of the normal course and schedule of your charter school. Very complicated. If you have a concern about a particular student, it's worth looking at on a case-by-case basis whether or not this student can make satisfactory progress. Are they too far behind to actually achieve a high school diploma? Another thing to note that the regulations do note that if a student is a student with disabilities, that child's satisfactory completion of a high school diploma is amended to mean satisfaction of the goals in the IEP. So it's a little bit different for students with disabilities.
Exception.
Oh, yes,
Job
thank you.
oriented.
Don't let me forget. There is an exception that would allow us to serve students who are over the age of 19 with actually no limit, so even past age 22, for schools that have an exclusive partnership with organizations like WIA, the Job Corps, Conservation Corps, Youth Build, and so for those students who are over the age of 19 through 22, if you want to go past that, you have to have this exclusive partnership with those organizations. And those students actually have to be enrolled in those programs. So you can't just say, we have a contract with WIA, and so we're going to take in 50-year-olds, haphazardly. All of the individuals that you are enrolling, that you utilize that exception for, actually have to be part of those programs. And so what we run into trouble with sometimes is that, for example, a lot of our schools have WIA partnerships, but I do believe that for WIA, we have to have an American citizenship in order to be a WIA member. Am I right about that? So some of our schools have struggled with regard to allowing their students to access it.
So now turn to the practical application of admission requirements. Just to reiterate, an admission requirement, if you have one, I would deem as any barrier to entry, any obstacle to free entry to your school, any preconceived condition, we'll talk about it, having to attend orientations to get an enrollment packet. All of these are arguably admission requirements. By law, they have to be stated in your charter. It's actually one of the elements stated in your charter. So again, you should assess, do I have any barrier, any limitation to a student's access to our school? And is it stated in the charter? If we want to add one, again, to align with your program in the future, just remember it's probably going to be a material revision of your charter. The second overreaching issue with these practical issues is that each admission requirement has to be compliant with law, it says. And well, what does that mean? Well, it would have to meet sort of two threshold tests. It would have to be facially neutral, meaning it does not discriminate on its face against one of the protected classifications, disability, ethnicity, nationality. And we can all think of something that would obviously violate that principle. The second one was a little more subtle and might depend on exactly how it's put together, but that it also, the admission requirement, shouldn't have a disparate impact, a disproportionate impact on a protected group of people. So if you have admission requirements, one of the things you need to be sensitive to and monitoring often is, what does my community look like? And we'll talk about this on the outreach. What does my applicant pool look like? And what do my student population look like? Am I seeing wide statistical variances between those pools of people? And if you are, you need to look at whether admissions requirements or preferences are playing a role in that, because it might come back to haunt you later, and certainly probably will around the renewal part.
Can I ask, is it okay to ask questions?
Please, actually, I forgot to mention, questions are fun.
So if you're finding that your Latino population does not match the population in your regular district, do you have to change your admissions policies to reflect that accurately?
So when we get to the outreach part, we'll probably be able to reach back onto that and discuss some of the proactive things schools can do to improve balance of diversity, or diversity more reflective of the general population of the district in which their charter was originally approved. You may. We're right now dealing with a renewal of a charter school down south where the district is critical of, for example, some of the things that are going on here, like required orientation programs as a condition to getting an application and as a condition to getting into your school. All right, again, facially neutral, probably doesn't create a disparate impact. Well, they're holding them at 10 o'clock in the morning. Now, it's a predominantly Hispanic community. If you look statistically in that area, they're dual income homes. Between 8 and 5 each day, most of the Hispanic community parents are working, can't attend an orientation. So maybe a little tweak to move it from 10 to 7 might be enough to really ultimately change the complexity of your admissions. So some of these that we see in charters that we've talked about up and down the state of California, and as you, again, think about these, A, if you've got anything similar, make sure it's in your charter. B, thinking about, all right, is it facially neutral? Would it create a disparate impact? Parent participation requirement. We have a couple of charter schools. Their programs are designed around, their academic program is designed heavily around parent participation in the classroom. And you could probably describe the academic environment better, but it literally means having one teacher and 4 or 5 parents in every classroom. And the only way that this school could do that and ensure that that mission would be carried through their whole charter was to mandate as a condition of enrollment that a parent sign a compact before they were enrolled, committing to a certain number of hours of volunteerism in the classroom. And they have a policy regarding exceptions. If you can't, you're disabled, or you have a job or whatnot, there are other ways they could make up some of the mandatory parent participation problems. Department of Education actually came to our rescue because we were trying to get this charter approved, and the county had some questions about whether an admission requirement requiring parents to sign this compact was legal. And the Department of Ed, in your materials you'll see, wrote an opinion that said yes, it was facially neutral. There's nothing in the law that prohibits a charter school from having this type of admission requirement, and there are charters that have this mandatory parent participation as a condition of admission. Again, if you like that notion, it's an admission requirement. It would have to be in your charter, which if you don't have, would have to be amended. I think some of the questions that come up, just saying, it would be, again, is it creating a disparate impact in that particular community? And we've looked at the general population there, and it's not.
One of the questions of the Department of Ed, very specifically fails to address is whether you could actually disenroll a pupil for the parent's failure to actually complete the agreement. And I think they purposely failed to address that because that's much more of a dicey issue. There's due process considerations when you're disenrolling a child for the sins of the parent to fail to comply with the agreement. And our office has always taken a fairly conservative approach at asking our clients to be very careful to consider other options short of disenrolling a pupil for the failure of their parent to complete the requirements. And so inevitably, the parent participation agreement is a sort of a deterrent to encourage the parents to complete the volunteerism without actually with potentially very little teeth. because of the fact that there is concern that we would be violating the students' own constitutional rights if we actually punish them by disenrolling them for their parents' sins, so to speak.
When we say disenroll, there are really only two ways a kid gets out of your school. He or she leaves on their own, parent pulls them out, or they're expelled. So, or the school closes. Obviously, we don't want that to happen. But there's no technical disenrollment. It's expulsion or voluntary dismissal.
Did they speak at all to any fees associated with becoming a volunteer, the clearances and the expenses of
That's a
a
good
volunteer
question.
and being cleared?
Can you repeat the question,
Yes.
please?
Yeah, I'm sorry.
Do they speak at all to any fees that are associated with becoming a volunteer, like for example, fingerprinting fees? And actually, they don't. That's a really good question. We've not seen any legal opinion that says that volunteerism cost, so to speak, is tuition. I've not seen that yet, but I certainly understand the question that you're raising. And most schools that we've seen do require their parents, volunteers, to take on their own fingerprinting costs, with the exception of offering up sort of help for volunteers that can't actually afford the cost of it. But yeah, that's actually a good question.
I don't
as to
think there was any legal requirement to background check your volunteer.
there certainly is not. I mean, that's a good point to raise.
Supervision of certificated employees. So I think some of these schools are actually not requiring their parents to do criminal
That is
background
a good
checks.
point.
Given some of the most recent press around issues associated with teachers and students and parents and students, obviously our heavy recommendation would be, I think it's $35. I mean, I admit if you've got hundreds and hundreds of parents, it adds up, but for each parent alone, it's a commitment that you might want to think about implementing. One of the other requirements that we mentioned is the required orientation program. Schools find that this is a great way to find parents and kids that are best aligned with their program. Have them come down to the school, have them visit the school, meet with some of the teachers, learn about the curriculum, learn about the teaching methodologies, learn a little bit about the mission, the way the school is governed, and that sort of thing. And I've heard a lot of good stories that really actually weeds out a lot of parents who are just looking to drop kids that are unsuccessful in another program because they may learn that it's going to be extremely academically rigorous, or that it doesn't have but certain aspects of the comprehensive high school, for example, the band or the football team or whatnot. And so they actually then, when the applicant pool comes in, they get a much cleaner and well-aligned applicant pool. Again, facially neutral, disparate impact, again, probably not, especially if you're cognizant around how you hold these orientations, and you hold multiple orientations, and you might even bring in an interpreter and produce bilingual, multilingual information for all the parents depending on your community. First to college is another one of these areas that we see as admission requirement. That the biggest difficulty for charter schools in implementing a lot of these is a failure to define in advance exactly what a lot of these mean. What does the mandatory parent participation engender? How many hours? When do they have to be done? Like you said, what happens if they don't do it? First to college, what does it mean to be first to college? What if it's a single child? What if they have a stepfather who's gone to college? And these things, all the things when you think, oh, first to college, that's easy. The two parents haven't been to college. The child therefore gets to get into this particular type of program. It's the failure in advance to sort of predefine all the different issues that could come up with fostering and cousins and stepchildren and all different domestic partners and everything else that can come up in the state of California, that you start to run into problems because you start making up decisions on the fly and you're not documenting that. You may be changing your policy that's actually in your charter. And the worst case scenario is you actually may treat two similarly situated children differently and run into trouble, especially if the one student that gets in under this rule is Caucasian, the other one is maybe a minority student, and they find out that you actually applied the rule earlier and had this disparate impact. Do you have anything about first to college?
I was just going to mention that first to college is awfully hard to track. Schools, I think that it's a good idea that's really hard to actually implement because it's hard to prove the absence of someone having gone to college. You'd have to background check them and see if they have a diploma in their past. And we've seen parents complaining that so and so pulled up in their car and they have like an alma mater sticker from Cal on their car, and it raises questions that are just hard to enforce. So it's a hard enforcement one.
The next one, letter of recommendations, we've seen only a few times, and it was heavily criticized by the school district in where it was going on. Again, it was not that I don't think in the case, it wasn't that they were evaluating the letters of recommendations as much as, again, putting in another hurdle another obstacle to find kids and parents who were really motivated to join this school. It's kind of like, got to attend a mandatory parent orientation, you got to come with a letter of recommendations from your teachers from prior site. The district criticized it as elitist. They also criticized it as discriminating against students with special needs who may not have 7 teachers in a day to be able to garner these types of letters of recommendation.
Recently working with the state, they said, we don't like the letters of recommendation, take them out.
Yeah.
So, the Department of Ed, at least recently, is coming out with, we don't like any extra barriers, and they felt like the letters of recommendation is something that if you wanted to get after you've done your application process and just for your enrolling students, to sort of find out a little bit more about the students that are enrolling, great, but anything pre-lottery, they were not comfortable with.
Auditions, there's anybody in here who's like performing arts or type of, we have schools in Oakland and Thomas and other areas of the state of California that have fine arts, performing arts, and they have as part of their admissions requirements, auditions. You don't see it all that frequently, but they want to make sure, again, that certain children come in either with a certain background, skill, or expertise, or that they have a certain base level of understanding so that they can benefit by the program. And again, they don't just, it's not like an American Idol search and we've got people coming to just sing to see if they can get into the performing arts school.
I was going to mention that if you do have an audition process, it's really important that you consider accommodating students with disabilities as part of the process. That we have seen some questions about whether a student with a disability could fairly participate in the audition process. You want to make sure that there's really no barrier to a student with a disability participating in that audition process. The best audition processes that I've seen have led instead of saying you get in or you don't get in via the audition process, instead that the students who scored the highest got a certain admissions preference in the public random drawing. I've always felt a little bit more comfortable with that than a you get in or don't get in, especially given the legal requirement that we're going to talk about in a bit, which is once you have more students who wish to enroll than you have capacity, the law says we have to do a public random drawing, a lottery, and an audition really doesn't feel like a lottery at all. And so, my suggestion would be you be very careful how you use the results of the audition. If you just, and that you make sure you accommodate as necessary.
You're on the next couple.
Yes, with regard to essays, again, this is just another barrier. And again, you also would, with regard to an essay, have to consider students with disabilities as well and accommodating in this regard. In my recent dealings with the state, they also had a charter school remove this as an admissions requirement. And they said, if you want to do it after you've done the lottery and require all your enrolling students to put together an essay, basically letting you know a little bit more about themselves, that's fine, but as a condition of enrollment itself, an admissions requirement, at least the state recently was not comfortable with it. With regard to GPA, we have a small number of schools in our state that have academic requirements, and so GPA is really meant to describe any academic requirement you might have. So we've seen schools that say you have to have a 3.0 or above coming out of 8th grade to enter into high school, for example, or you've had to have completed algebra and passed algebra as an admissions requirement, and a certain level of proficiency, exactly. So all academic type requirements, and the question has been asked, is that legal? And our answer is, generally speaking, that it is in fact legal. However, you have to be very careful in its implementation. Number one, again, we cannot discriminate against students with disabilities, so we need to make sure that they are accommodated in the admissions process. Number two, we have to consider whether there is a disparate impact on any specific population, any protected classes. Now, we do have a case in California, in our Ninth Circuit, that had to do with Lowell High School. And in Lowell High School in San Francisco Unified School District had a high academic requirement, and there was evidence shown to the court that its academic requirement at this high school was disproportionately affecting Latino and African American students. But the court found that that the admissions requirement, the academic requirement that they'd put into place, substantially furthered a legitimate public purpose, and that as such, it was an okay legal admissions requirement, and so it actually stood by it. Now, things to consider from a practical basis is any one of these admissions requirements, such as GPA, essays, and letters of recommendation, you will run the public perception risk of people saying you're cherry picking. And they will discount your success because they will say, of course you're successful. Anybody can be successful if you pick the cream of the crop. Now, that may not necessarily be true. I'm sure it's not true. But just understand from a practical standpoint, the more admissions requirements you have, the more likely it is that people are going to make these arguments. Now, for quite a few of us, we have no admissions requirements and we still get told that we're cherry picking, right? So some of us say we're going to get accused of it anyway, we might as well put them in.
The districts forget they're running GATE programs themselves that have academic and behavioral expectations as limitations. And charter schools are intended to have as much flexibility, if not more, than school districts, but that's not the way they see it, obviously. The most districts' paradigm is that you have to admit and be open to all, and you can't design a program for any specific goal.
With regard to single gender, gender balancing, we do often get, we get a handful of calls every year about, can we gender balance our classrooms? Or can we have an all-girls school or an all-boys school? In that same case about Lowell High School, they actually found that the district's efforts to balance the genders in the high school was actually illegal. And so the same case that said that academic requirements were legal said gender balancing is illegal. Now, we have a requirement, as Paul said, that we cannot discriminate on the basis of gender. We also have Proposition 209 in our state, which clearly states that we cannot engage in any affirmative action with regard to the operation of public education. We did have an all-girls charter school in California, or I should say, we do have an all-girls charter school in California. Anybody here from that school, by the way? No, okay. I would love to chat with them. So we do have one that advertises itself as an all-girl charter school, and some of my investigation of this school, I found that they actually submitted a waiver request to the State Board of Education for a waiver of the requirement that they not be prohibited from discriminating on the basis of gender. And that waiver went to the State Board of Education and it was denied. And they actually analyzed it under Proposition 209. Proposition 209 says that you can have bona fide qualifications specific to gender if it's necessary to your public education, to the operation of public education. When the State Board of Education analyzed this school, they said there was no bona fide qualification related to gender, and so they said that the school could not be an all-girls school. They could not eliminate boys from the admissions process. Now, interesting, I'd like to see a show of hands how you feel about this. This school was a school specifically set up for women that were pregnant and parenting teens. Many of you had been sexually abused, and the school made the case that they were setting up this program just for girls because many of them were fearful of males and really needed to learn only in a same-sex classroom. And they were going to get a lot of social skills training, a lot of counseling as part of their education. So anybody feel like they made a pretty good case for themselves? Yeah, I mean, I felt like they made a pretty good case for themselves. Well, the waiver was rejected. The state said, if you want to do what you're going to do, you still can focus your educational program on serving the needs of these women, and you still can do outreach just to women. And if you had a specific issue related to a single male that wanted to enter the program, you could seek a court order to prohibit their admission. So it was an interesting waiver case. For now, I think the advice is that probably trying to have an all-girls or all-boys school or trying to balance your classroom's gender is probably not legally permissible, and it's unlikely that we would make a case that it would be permissible. With regard to homeless students, I just wanted to point out the McKinney-Vento Act, which requires that we do not delay the enrollment of students who do not have residency information or CUME files because they are homeless or foster youth.
Do you have the citation on the Lowell case?
On the Lowell case, I do have the citation. It is 501 P2, I guess, 1264. Is that right?
Not P.
No.
F second.
F second,
Yeah.
sorry, bad handwriting,
Yeah.
no glasses. I was thinking P.
For those, the men in the room, you'll appreciate the Lowell High School case. What the district, San Francisco Unified was trying to do was ensure that the Lowell High School had 50% girls, 50% boys. But in order to do that, because they were taking the top 15% of the students out of the 8th grade classes, they lowered the GPA standard for the boys. I was really offended by that. Come on, guys, get your act together. All right. Geez, so the court struck it down. I was happy about that. All right, admissions preferences. So switch around from barriers to entry, admissions requirements to admissions preferences. These are, now we start talking about admissions preferences when we've got kids that qualify through the admissions requirements. And what we're going to get into here is a little bit about how admissions preferences and lottery all play out about how kids get in. Again, admissions preferences are different than admissions requirements. Admissions preferences play into those met that threshold, how they may get in, and what order they may get in, and the like. Preferences have to be in your charter. Again, it's one of those areas where the law specifically says they have to be in your charter and approved by your granting agency. So anything that, as we go through some of the examples, that smacks as a preference, or the way you change the order of kids getting in that would be a preference, has to be or should be found in your charter. Preferences only come into play when you're oversubscribed. So when you've defined your facility capacity for a year, or you've got 60 kindergarten slots coming up next year, if you do an open enrollment window and you only have 50 applicants, preferences don't come into play. The earlier application, as I said, you admit all students who wish to attend your charter school comes into play. But I know most of you, and I think as if I show of hands, how many of you have waiting lists? Yeah. And I'm never shocked now to find out that in the first year of operation, new school, maybe operating out of a warehouse, untested teachers, and the school's got maybe 100 slots open for kindergarten, first, second, third grade, and they've got a waiting list of 400 kids in their first year. That's the pent-up demand that we have in our state. So these preferences issues become very important, very fast, and you get a lot of very angry parents if these things aren't adhered to, and including angry school districts. So there are required and optional preferences in the law. The first one speaks to the required ones, 47605D, poorly worded. First of all, says that you exempt existing students from the lottery process. And then the next sentence says you give existing students a preference. So what is it? Well, we exempt them. I mean, to me, if you're in your second year of enrollment and beyond, so you have existing students, you find out from the year prior who's coming back. Those students automatically matriculate and are rolled up in the next program. And then you're looking at defining what kind of capacity you have at each grade level to enroll those students. Then you have a couple other preferences stated in the education code that apply to two different types of charter schools. You have startup charter schools and conversion charter schools. Anybody a conversion charter school here in the group? Okay, got a few conversion schools. Starting with the majority of you, the startup charter school language says that in addition to exempting or preferring those existing students, you have to give a preference to students who reside in the district to which you submitted the charter. Conversion schools, it's a little different. You mandatorily have to give a preference for students who live in the former attendance area of the school at the time that it was converted. Former seems to mean it gets locked in historical place, and you need to know that and keep track of that for purposes of applying this preference when going forward. Optional preferences in the next two bullets, Education Code Section 476053. This is one of those ones in the code that says you can give a preference if you're located in an elementary attendance area where 50% or more of the students qualify for free and reduced meals. You can give a preference for students living in that attendance area. Not just for kids who qualify for free and reduced, but to kids in that particular attendance area. Here, like other provisions in the Charter Schools Act, it was aimed towards trying to help kids that really are socioeconomically disadvantaged. And this is one of the places where the legislature said, here, while we generally don't let you design your admissions preferences based on residency, other than what I just said before about conversion schools and the district preference as a whole, we will allow you to pick an elementary attendance area if you want to add on. Lisa's going to talk about in a minute what that means if you go through the grant program. And then the last one, 47614.5, SB 740, is the Charter Schools Facility Grant Program, the one where you get reimbursement for the state for rents and leases of your facilities. And that actually allows you to qualify for that reimbursement up to $750 per ADA to cover up to 75 or 70% of your annual rents and leases for your facilities. If you are A, serving a student population that's more than 70% free and reduced, Or B, you reside in an elementary attendance area that has met that threshold of 70% more than free and reduced, and you include a preference in your charter for kids in that attendance area. So again, these are optional. No one mandates you to go through SB 740, but if you want that money, which is pretty critical to a lot of you who don't have facilities, then you have to include that preference if your student population threshold does not already meet that level of
I know you have a lot of questions. Let me, 47605D also has a sort of a catch-all provision that basically says you may also have other preferences as long as they are in the charter authorized by they're authorized by your authorizer, so they've been approved by your authorizer, and they're not otherwise illegal. So we read that to mean not otherwise discriminatory, not otherwise requiring some sort of tuition or some sort of religious connotation. So as long as they are not, that they are legal and they are approved by your authorizer, there's sort of a catch-all provision in 47605D that would allow for other preferences in the charter. And so we're going to start talking a little bit for our startup, our new charters in the room, as to what happens to all of these preferences when you are receiving money under the grant program. So before we do that, why don't we take just a few questions? I know we're kind of, it's a tough timing presentation. Let's just take a few. I know I saw a couple back there. Right there, yeah.
My understanding was that we had to give preference to students who reside within the district in which we're housed. Is that not true?
Well, are you a startup charter school?
No, we've been around for.
Well,
So so the question was, do I have to give a preference to the district where we're housed? And the answer is that you must give a preference to the district that's authorized you, and unless you are a conversion school in which your preference is a preference for the students who reside in the former attendance area of the school.
and one thing to add, as Lisa said, these other preferences we'll talk about on the next slide. The others that you may be able to add, and some of the ones that you've commonly heard, siblings, founders, that sort of thing. There's nothing in the law that dictates the hierarchy of how those are placed. So we'll talk a little bit about that in the next slide, just so if you're wondering.
James, and then right here, and then one in the back, and then I think we'll move forward and try to.
Best way to verify a district resident, how do you do that? When people lie about their.
But, what's the best way to verify district residency? Usually it's a utility bill that's requested. That's generally what's utilized for district residency. I know that, it's not always a perfect answer, but that's usually what's utilized.
I was wondering, do all of these preferences and requirements apply to a non-classroom program based under or among a site-based program?
That's actually a very good question. Yes, they do. The question was, do all of these preferences also apply to non-classroom based charters? And the answer is yes, they do. Now, non-classroom based charters also have a limitation in enrollment that they can only enroll students with in their county and contiguous counties. And I'll be presenting at the end of today on non-classroom do's and don'ts, and we'll talk a lot more about that. And then I had one in the back.
I haven't heard of a lottery forever in a non-classroom based
Actually,
school.
Paul's
so.
bringing up a good practical point, is that in the most cases, not all, mind you, but in most cases, non-classroom based charters grow their capacity to meet student demand. But that's not always the case. I mean, we do have a handful of non-classroom based programs that they set a capacity per each one of their resource centers and based upon their teaching population, so that they don't go over their pupil-teacher ratio. And so there are non-classroom based schools that have to do a public random drawing. I figure we just take one more and then move on.
We're a county wide charter.
A countywide benefit charter.
Right. Now, the requirement where does it step up from district to county?
It does.
Becomes a preference there, is that?
That's right. So if you are a countywide benefit charter, which means you've been approved under Education Code Section 47605.6, this is a very separate authorization process. You went directly to the county for approval as opposed to getting denied at a district level and going up on appeal to the county. If you are a countywide benefit charter, your preference goes to the county, students who reside in the county as a whole. If you are a charter approved by the county or state on appeal, meaning you were denied at the local level and you appealed and were approved, then your preference continues to remain at the district level, which often causes a bit of angst. Is, you know, when we talk, that's one of our practical issues that we mention in a later slide. So let's jump real quickly into startup grant. How many of you are anticipating getting the startup grant next year? You know, and so a lot of you probably do have these broader preferences written into your charter. Sibling preferences are one that's often come up. Founder's preference, children of employees, very frequent. Free and reduced lunch preference, sound familiar to a lot of you. Now these are all legally compliant preferences. However, the Charter Schools Grant Program adds an additional layer of requirements on charter schools while they are receiving the Public Charter Schools Grant Program funds. So for all of you who have been operating 10 years and you're thinking, does this apply to me? The answer is no. So I'm going to go quickly. But if you're getting the Public Charter Schools Grant Program funds, when the state approved the RFA for the Public Charter Schools Grant Program, they agreed to comply with federal non-regulatory guidance. The U.S. Department of Ed put out a document that's in your handouts today. I think it starts on maybe page 6 or 7, that provides the U.S. Department of Ed's guidance on admissions requirements in charter schools. Now remember, these are for charter schools throughout the entire United States, not specific to California. And remember, it's non-regulatory guidance, which usually means non-binding. And so if any of you are in a district where the district has all of a sudden decided that you should be complying with this non-regulatory guidance and you are not under the grant, you sometimes have to politely remind them that this is non-binding guidance from the U.S. Department of Education. So the state has, in fact, adopted it as part of the Public Charter Schools Grant Program funds, and it very severely restricts what preferences are allowed to be in your charter. Now, if you have them in your charter, usually it's okay to just footnote them in your charter and say they will not be utilized during the time that you're receiving grant funds. So I thought I'd just really quickly mention what the grant allows. The grant allows certain exceptions to your lottery process for siblings. They also allow a preference for an exception, they call it, for founders, children of employees, and children at a worksite charter school, if you had such a thing here in California, up to a combined 10% of total enrollment. So an exception for that chunk of individuals as well. They also allow an exception for children who are enrolled in a public school to be converted. So not that they reside in the former attendance area, that they're actually enrolled in that public school to be converted. Now they also allow a weighted preference in a single weighted drawing, so which means you can give additional weight to an admissions application for certain individuals, and those are students who reside in the former attendance area of a public school to be converted. Those also apply for our startup charter schools. The district preference, the students who reside in the district get a weighted preference. Also, any student who is moving schools via the No Child Left Behind public school choice, anybody engaged in the public school choice options, they are allowed to be given a weighted preference. And then there's a general sort of catch-all that says any type of preference that's being given to comply with Section 504 of the Rehabilitation Act, Title VI, which is non-discrimination with regard to race, Title IX with regard to gender, but our Prop 209 generally would prohibit any of those preferences, but the grant would allow those preferences. Now, this is more important. What does the grant not allow preference for? I always think this is really interesting. It wouldn't allow 47605.3 preference if you're giving preference to students who reside in an elementary attendance area that's 50% or more free and reduced lunch. It doesn't allow a preference for those SB 740 kids that reside in an elementary attendance area that's 70% more free and reduced lunch. What that means, folks, is that if you plan on getting SB 740 reimbursement based upon that elementary attendance area being 70% or more free and reduced lunch, you have to choose between SB 740 reimbursement or grant funds, because what the CDE has said is you only can get those grant funds if you yourself are 70% or more free and reduced lunch, because the grant, the public charter schools grant, does not allow it. So once you finish with the grant, you could then go get the SB 740 reimbursement, assuming the money is still there. They also don't allow for a general free and reduced lunch preference. So generally speaking, you can't have a preference for students who qualify for free and reduced lunch. A lot of our schools have preferences. Those can't be utilized while you have grant funds, that your public charter schools grant funds. You can't create a feeder pattern while you are utilizing grant funds. So if you're creating a middle school to have your elementary school students feed into, you can't, while you're getting grant funds, create a feeder pattern and give a preference to those students. The other thing that this non-regulatory guidance says is that you have to comply with any desegregation orders that are in place in your authorizing district, and they also mention very clearly that you can't do any gender balancing. Most practically, the biggest impact that this has is it really prevents our schools from utilizing a feeder preference during the grant program. I think that's the biggest impact that we have seen. And also this SB 740 issue is a huge issue. Well, the founders group too. If you have a founders group that's going to make up more than 10% of your total enrollment, that can be an issue during the grant as well. So some practical tips with regard to working through these grant requirements. One thing to note is that when you are about to finish spending your public charter schools grant funds and you are enrolling the class of students that will be in the school when you are no longer spending grant money, you do not have to comply with those strict grant restrictions regarding enrollment preferences. You can go back to the preferences that are in your charter that might be broader than what's allowed under the grant program. So you can bring back your free and reduced lunch, your feeder preference, etc. Another tip that the non-regulatory guidance actually gives us is that you can do an early lottery. And so before you get the grant, you could potentially enroll your classes years out. So they mention, for example, could you get, the way they answer the question is, could you give a preference to students who are coming from a private nursery school, preschool? And the answer is no, not under the grant. You can't give a preference to students who have gone to this private preschool. But they said you can, however, we're not restricting you from, before you get the grant, doing an early lottery and filling your grades out years. And so technically you could potentially do that. Now a lot of the schools we work with have been very, very uneasy about that process, and there are a lot of implementation issues to consider, but definitely worth considering if you've got a preference that you really have your heart set on, that the grant won't technically allow you to do. Sorry, I know that's really, I'll take one question on the grant issues.
I was in the grant training yesterday, and it seemed like a lot of folks in the room were kind of getting caught out on this, because what they were saying, what my understanding what they're saying is, they're checking your charter, and your charter has to say what that is. So you just made a reference like, well, you can go back to what your charter. According to what they were saying, they're looking at your charter has to say it. And
you make a good point. You absolutely make a good point. So they are going to check your charter, and to be clear, they will want to know that your charter allows you to have limited your preferences in the way the grant requires it. And so what we normally recommend, and a lot of you probably have this in your charter, is that you write the preferences you want when you're not under the grant so that they get authorized, but that you footnote very clearly the preferences that you will not be utilizing during the time period in which you're going to get the grant. And that way you've covered yourself in both instances. What I normally see is if you didn't have that in the first place, so you didn't footnote it out, normally the Department of Ed will actually ask you to go back to your authorizer and amend your charter so that it does in fact comply with grant requirements, which is of course, how many of you would like to go back to your authorizer? Yeah, not many of us. So if you get it done in the first instance, if you're in the process of writing the charter, make sure you footnote those preferences that you cannot utilize while you're getting the grant if you anticipate getting those grant funds.
The PCS guide is really good. When I wrote our charter, I wrote that whole section with that section of the guide open, and that was what I used to detail
did you use Appendix J, which is in our materials, I think? So just so you know, I think what you're referencing is in the RFA itself is an Appendix J where the Department of Ed has basically tried to harmonize our state law and the non-regulatory guidance, which is not an easy process because there's different terminology used between the non-regulatory guidance, which uses the term exception and weighted preferences versus our state law. And so if you look at the column called reconciliation, that actually will help you a lot. And it's in your materials, I think, on page 29.
So let's move on to the actual admissions preferences issues. One other thing I wanted to say, though, while we got into this issue about the lottery and preferences and the like, is that many of you might want to know, and this becomes important especially when you're dealing with your granting agencies around enrollment capacities, that there's a provision in the Charter Schools Act that says that a school district actually has to take or make reasonable accommodation to allow you to accommodate your growth, and can take no action to impede your ability to grow to meet pupil demand. So for any of you who are in LAUSD who has tried to amend your charter to increase your enrollment and the district says no, they're in express violation of the law. Now, getting to the admissions.
That's in 47605D.
Yeah. Yeah, it's a nice little handy reference tab. Getting back to admissions preferences again, just to reiterate, they need to be in your charter. So a lot of times the charter itself will say that the board will define a policy around the enrollment practices and procedures. And then what happens is the board starts coming up with preferences that work out in the hierarchy. And again, that's where you're starting to get documents outside the charter, just to let you know this is something that gets audited by school districts all the time. And that the preferences that are applied, again, have to be facially neutral and not create a disparate impact. Again, I want to re-emphasize that a lot of these preferences we're going to talk about are common preferences, founders' preference, siblings, and others, maybe even some of the feeder patterns. But where the schools get into trouble, again, is where they don't, again, define in advance what it means to be a sibling, or foster, stepchildren, foster children, are these cousins living in the same home? Are they considered siblings for purposes of this? And you just really should not be making exceptions on the fly and trying to define this in advance. We do see preferences for free and reduced and other at-risk preferences. I think that the hardest one with this, and I'd be curious what you think, Lisa, is that when you're doing the application process, which we'll talk about in a little bit in a moment, the application form is going to be very bare. Name, address, parent, phone number. You don't want to ask about prior student discipline. You don't want to ask about special education qualification. You don't want to ask about the free and reduced. Having all that information in advance and then going through the lottery is going to lead you probably to problems in the long run if for whatever reason your process led to all the kids that had checked SPED not getting into your school. So I don't know how you apply a free and reduced preference.
So a couple of ways so some schools do in fact require the proof of the free and reduced preference as part of the application process. It's certainly not illegal to do it, but what happens is, let's say you've got 1,000 applicants for 100 spots. Now you have 1,000 students' tax information proving their free and reduced lunch status, which most schools really don't want all of that confidential data. And so what we have recommended, and a lot of schools do, is they require the parent to sign under penalty of perjury that they do in fact qualify for free and reduced lunch, and then they basically notify parents as part of the application process that they will do a random audit after enrollment, where they will basically go through and randomly select individuals who said that they were in fact free and reduced lunch and ask for proof. Others actually say if you got in through that preference, once you've been enrolled, we are going to require the proof. So that's another way around it as well. Random is nice because you're not doing everybody. Others they want to know that every student is. And I don't know how many of you have a free and reduced lunch preference. If you have, raise your hand. But I can guarantee you will get other parents complaining that there are parents that have swindled you and got in, and they are not in fact free and reduced lunch. At my kids' charter school, they have a first to college and a free and reduced lunch preference. And this one parent has a Cal sticker on their car, and every year we get a complaint that that parent should not be at the school because they are not first to college and they are not free and reduced lunch, and they did in fact get in illegally, and there's really nothing the school can do at this point. That, it's sort of what's done is done. I don't think a bumper sticker is indicative of a college degree, but that's just me.
Well, Cal only gives out bumper stickers.
No,
right?
I see. Go Bears.
I went to Cal. That's okay. I can do this. Yeah. That's right.
My question was free and reduced lunch, so is it illegal then to have that, because we were told we need to put that in our.
It's not illegal to have the preference, and it's certainly not illegal to put it in your application. But what, normally, and we're going to talk about this in a bit, but normally we have an application process and then we have an enrollment process, right? The application is how do we get into the lottery? And then once we've done our lottery, we send out what a lot of you call an enrollment packet or a registration packet. Paul's saying it's much easier to get that information during registration. Otherwise, you have a ton of information on a bunch of applicants that are not going to get in. Also, the state has been very concerned with charter schools who are potentially asking quite a bit of information in their application, such as special education information, race, ethnicity, national origin. And there's a fear that you may be potentially discriminating against these students in the application process itself. And so they really recommend this sort of name, rank, and serial number application. And then they recommend you gather everything else you want in this enrollment packet. And so if you can design your process and still get what you want by taking out that information in your application, it's probably a safer bet.
Just do it blind, and that's what people are going to prefer. Founder's preference is very common right now, and actually one of the more controversial ones. What?
We got 15 minutes. Just
yeah, no, I saw it. Yeah, founder's preference right now. How many of you have a founder's preference? I would bet more than half of you do. Again, very common. And the department, the State Board of Education, the US DOE has all recognized the legitimacy of a founder's preference to get people involved in the development of the school. Some of the issues that come up recently are, well, when does a founder's preference end? Well, it doesn't end when the charter is approved. Most of your work actually starts when the charter is approved. LA, I guess, has a policy now that says, well, founder's preference still gets cut off by the time you actually put kids in seats and the school year actually begins. Again, you need to define it. How does someone become a founder? How much work do they need to do? How much time do they need to commit? So you actually lock it down. You have a list. And then at a certain point, you can't buy your way onto that list. You can't sell your founder's preference on eBay. These are things that are causing real problems for the charter schools movement right now. I mean, it's neat to say that you guys are doing such a phenomenal job with your schools, that there's this market now generated around getting kids into your school, and this is what's causing us some problems. So, is the question?
Yeah, so that's different than, like, we have board members. I'm not sure what we have now. I'm a little confused. So what about a board member who becomes a board member who's not a founding board member?
Well, you have to have the question is a board member preference the same as a founder's preference? And that really would be a separate preference, and also a legitimate preference as long as it's in your charter, authorized by your district. And so a lot of schools do utilize board member preferences, and that allows them to attract the best possible board members, at least they believe. So that is a possibility as well. And that sort of goes to that fifth bullet there as well, that it's common to have a children of employees preference, is also hoping to attract really highly qualified employees as well, by allowing a preference for the children of employees. Usually these preferences yield a very small amount of students, and the authorizers don't find them very troubling. It's the founder's preference that troubles a lot of authorizers. It seems elitist. It seems that you are cherry picking, and so you need to go above and beyond to show that you are doing enough outreach to engage a very broad population of founders, so that every parent in the community, regardless of race, ethnicity, socioeconomic diversity, has an opportunity to become a founder. And I think that's part of what the allegations against charter schools generally are. I didn't even have the opportunity to become a founder. They basically went with their own clique and created founders, and that was it. We're going to keep moving, and we'll stay at lunchtime. For
some of these are
self-explanatory.
Obviously, creating a feeder pattern is a matriculation pattern between one or more schools you might be operating. Lisa just said you have the children of board members, children of employees, common patterns. Lisa's talked about the restrictions there. Zip code preferences are what they say they are. If you're you think you're going to do a little bit of diversity balancing by actually applying preferences with certain zip code areas, maybe lawful, could get you into problems. 209, it's a legal issue for sure that you want to explore. Lisa, you've talked about the grant restrictions regarding feeder patterns and SB server.
Sibling is not a legal definition, which, it's tough for schools, but you should define it. You should try to work with your board to set a policy defining sibling, just in the same way you would define a founder. because there are many variations on the same theme of sibling, and you will get parents trying to say, I'm the cousin that lives in the same house, or I'm a stepchild. So you should endeavor as a board to define siblings so that you are consistent in the application. The biggest thing you want to avoid is inconsistently applying the term sibling so that it allows one family's sibling to get in and not another's family. We're going to keep going and take questions
Everybody
at
hold
the
their
end.
questions. We'll stick around and answer questions just so we get through the materials. Obviously, the county-approved charters, we said before, preference for county-wide. Language fluency is another one we see where bilingual programs want to have language fluency. And whether you can legally or not, ask for, and whether that's discriminatory because you're trying to get a 50-50 balance, that is a bit of a question we could, if it comes up.
And we do have quite a few immersion programs that do make preferences or even hold separate lottery pools for language. And generally speaking, we have not had a challenge or a complaint, but we have recognized that it is potentially an issue that could arise in the future. The Department of Ed recognizes the need educationally, the legitimate need in an immersion school to balance the language abilities of students, and generally has been supportive of it. With regard to the public random drawing, we've talked about the fact that once we have more applications than we have capacity, we must hold a public random drawing. The Public Charter Schools Grant Program describes the public random drawing as a single weighted drawing. And they allow for certain exceptions to that, as I described before. I'm going to switch the slide real quickly.
So first come, first served policies, I don't know whether you see any of these anymore. I think
We
we've, well, all right, well, hopefully we're not seeing any more because as we've said today, if you are oversubscribed, you need to hold a lottery. So we can't, and at least we'll talk about this in a second with staged windows, you should be establishing well in advance. You have an enrollment period. Parents should all be notified, be given a broad-based opportunity to get into that enrollment period. It should close. If those numbers exceed your capacity, you need to have a lottery. You cannot tell people, just send us your enrollment application in the fall and we'll put you in, and then put the next student in and put the next student in, and then think you're going to do an enrollment lottery after you actually exceed that capacity. Comments about staged.
When we are not in the grant periods, we're not receiving public charter schools grant funds, generally most charter schools do their lotteries in stages. What I mean by that is they separate their applications out by preference category. So they put their founders here, their siblings here in a pile, their children of employees here in a pile, and they go by priority down the list. If I took all these students in, would I be over capacity? If the answer is no, I let them all in. I go to the next preference category. If I took all these students in, would I be over capacity? If the answer is yes, I start drawing within that group. And then I keep drawing and creating a wait list randomly. That's generally how it's done at most charter schools that are not receiving the public charter schools grant. If you're receiving the grant, it's important to know that because they defined it as a single weighted drawing, they will require that you can do the stages for the exceptions under the grant, the siblings, the founders, and the children of employees. The children who reside in the children who attend the school, the public school to be converted, they will allow those to be pulled out and done in stages, as I described. But everybody else gets dumped into one single drawing, and your preference that are allowed under the grant are given additional weight. How much weight? It's whatever you've defined with your authorizer, whatever the weighting preference is. It could be 2 to 1, it could be 100 to 1, it could be 1.1 to 1, just that it's given a weighted preference.
Applications that come in after the drawing, again, you should establish firm deadlines. Documentation of this is critical. We actually like to see, I don't know if you've ever heard of a bait stamp device. It says, our window closed at 5 p.m. on Tuesday. Boom, boom, boom. Everyone that got in should be clearly documented as in. Enrollment packets that come in afterwards, document afterwards. You're going to get the parent who says, I dropped it off at 5 o'clock, who's going to try to argue. And you need to be able to make sure you can go back and prove, if you ever had to, hopefully not either to your granting agency or court of law, that you shut that window, and that those people can be held over to another enrollment pool. Because what you're going to do, as Lisa said, go through the lottery, hopefully you're oversubscribed, and you've got kids that didn't get in, they're going to go on the wait list. Those people who got in after the application window should not be put at the end of that wait list. They should be held until there's either a vacancy or you go through the enrollment process again, and you may actually again determine whether they're oversubscribed, and those parents don't get in on a first come, first served basis just because they came in late, they go back into another lottery process.
So real quickly, just some steps to take in avoiding some common mistakes made in lotteries that we've developed over the years. How many of you use like chips or ping pong balls? You know, make sure, or how many of you use paper applications and draw randomly? You know, so a couple things to think about. Use something heavy to draw, because if it falls on the ground, you want to be able to hear it. We have had a number of schools that have left the room and found slips of paper on the ground that never made it into the lottery. And the question becomes, oh my God, do we have to hold the lottery again? So make sure you have something that has some weight to it that's actually going to make a tinkling sound or something. That's probably not the right accurate. Dang it.
There's always one thing you say.
Yeah, something. Yeah. Well, see, you know, it adds some color to the presentation. Make sure it's something that makes noise. Now,
Thud.
Doing a rehearsal of your lottery is a really good idea. You just are, you know, any of you who have done a lottery would probably attest to this. The things that go wrong during the lottery are just unbelievable. Families that come up and tell you that they put their child in the wrong grade, you know, losing applications, a ping pong ball machine that doesn't work. Do a dry run. Some other tips include, if you can use a software program, there's some pretty clever ones out there. One I've seen use a randomizer. Again, dry run it to make sure you understand how it works. I like suggesting that you do have a big overhead so that parents aren't reliant upon you screaming it out. They can see the numbers on some sort of screen. Otherwise, you get a lot of parents coming up going, what did you say? Did you say 101? Did you say 232? Also, you want to make sure that you have a lot of volunteers staged all around the room that can answer questions that are not involved in the actual drawing, because you don't want parents coming up to the people who are drawing, because it's going to cause confusion. It's going to mess up the process. The last thing I would suggest is that you have sort of 3 people up there. 1 person drawing and 2 people who are verifying what's been drawn, so that you have backup documentation of what's been drawn in the lottery. And then the last thing that we had here is about confidentiality. I think you already moved my screen, thank you very much. Is that, you know, a lot of schools are still yelling out names. Like, you know, John Smith, you know, you got in and everyone's like, hey, John Smith. I would not recommend you do that because you don't want somebody saying, wait, John Smith got in. Is that because he's free and reduced lunch? Is that why he got in? Or he's not free and reduced lunch. I'm going in and complaining. Much better to assign applicants numbers ahead of time. Notify them what their number is, either in the mail ahead of time or when they come in and check in for the lottery, and then just yell out numbers and not actual names. You know, there's no legal requirement that these names are confidential, but it really causes some practical problems if you're yelling out student names. Very uncomfortable situations.
Let's close on the pupil outreach issue that interrelates with all of this. The Charter Schools Act required your charter to actually state in a reasonably comprehensive fashion the means the charter school will use to achieve, expects you to achieve, at least the way the code is written, pre-Prop 209, ethnic and racial balance reflective of the governing general population, residing in the school district in which the charter school was submitted. Now, that sounds like you have to engage in some sort of affirmative action program. But then we had Prop 209 in 1996, passed by the voters, amended the Constitution, clarified we cannot discriminate or grant preferential treatment to anyone, including in education, based on race, sex, ethnicity, national origin, and the like. It really changes the dynamic of what that early code section says. Most people, most lawyers, most school districts understand it to mean now that you have to employ practices that are attempted and designed to achieve, strive to achieve a racial and ethnic balance that's reflective of the general population in which your school district was originally submitted. You can't, there's an issue here, probably won't have enough time to get into it, about local authorizer integration plans, consent decrees, DSEG court orders, about whether or not charter schools are in or out of them. Sometimes that comes up with your school district. They may dictate that you comply with it. If you ever have to, if you want, talk to a lawyer about whether or not they're applicable. County approved charters, we've said before, if you're up on appeal to the County Office of Education, this we've talked about as a preference for the in-district. You have to apply the preference for the students of the district you originally denied. And arguably then this district balancing issue for diversity is measured by the general population of that district, not the county as a whole. So it'd be a little more of a discrete population. Countywide, statewide, different issues that we talked about a minute ago. And former conversion schools, obviously you're very locked down with that former attendance area, and even though the code says you have to match the general population of the district in which you are approved, most districts realize that if you've got a high school, it only accommodates 3,000 people, and every year you're at capacity and you're just drawing from the attendance area, and that attendance area doesn't have a great deal of diversity, there's not going to be a lot you can do, although many charters do engage in a lot of outreach outside the attendance area to make sure that at least they show each year that they've tried to achieve balanced racial and ethnic diversity.
You know, at renewal, a lot of schools do in fact get accused of not being reflective of their authorizer. I know the state board really struggles with charter schools at renewal that are not reflective of the district in which they're located, and they ask for tons of data. What have you been doing to outreach? You should have an action plan, and I put a little sample action plan here that shows where you're doing your outreach, how you're doing your outreach, and the frequency that you're going to do. And then you should track your compliance with it. You shouldn't wait until a day before your renewal is due to say, shoot, did we do that outreach, or do we have documentation of that outreach? It would be far better to all along in your 5 years have a really good documentation of all of the outreach that you're doing so that you can show that you've completed it. You also should try to show that you have considered the efficacy of your action plan for outreach every year. Has it been successful? Have we amended it as needed to get something a little bit more successful going? You know, so if we're doing a table in front of the Walmart every year and that's really not yielding diversity, maybe we should be moving our tables to outside the Head Start. You know, we should be looking at different ways to do our outreach. So ensuring that you check the efficacy as well. Now, a lot of clients have said, well, could we put the racial and ethnic questions on our applications itself so that we can track our applicant pool and show that our applicant pool was diverse, but the lottery itself caused the imbalance? And so we have said, gosh, you know, that really goes against the state struggle right now that is telling us, make your bare bones application. And so one thing I could suggest is that you could put a separate piece of paper together with your application that says voluntary information to assist us in understanding the efficacy of our outreach plan. How did you hear about the school? Was the information that you received helpful? Would you be willing to give us information about your race, ethnicity? Free and reduced lunch too. Even though the law doesn't say we have to do outreach for free and reduced lunch, how many of you got trouble with your authorizer telling you that you don't have as many free and reduced lunch students as they do? How about special ed? How about EL? You know, same sort of thing. You know,
And the EL and the special ed populations aren't even mentioned in this ed code, but they will come up in renewal.
Right.
They will come up in renewal. If you are plus or minus 5% outside, and always lower, they claim, from the district's student population, they will claim that you are cherry picking, you're not doing your best to try to recruit a broad and diverse student population.
Not only have we seen it come up at renewal, but now we're now seeing districts actually attack schools during their CUP processes to get zoning variances. They're not reflective, and so you should not give them a zoning variance. Unbelievable amount of attacks related to race, ethnicity, and free and reduced lunch.
I can't emphasize enough documenting your efforts. Take pictures of your tables with your families trying to register kids in front of a local church or community centers and that sort of thing, because it's at the end of the day when we're trying to prove to the board the efforts that you've done, it's one thing to just say, yeah, we went to community meetings. It's another to literally show the dates on a calendar and pictures, the multilingual publications, the fact that your website is in different languages, that you had a geographic area where you understood the district and you went into particular areas in the district on a map to pinpoint diversity. How can they refute it? If you've done all that, and at the end of the day those populations aren't coming, you're not to blame. But they will, unless you're able to do it on paper, to be able to prove it on paper, it's a tough argument. And we always get, we get beat back on these issues.